Day 3 in the Ashley Benefield case, and what do you know? The state already rests. After only 3 days of testimony, the state rests. And now the defense is going to begin their case, and they only have a day or so of testimony. So this case is going to be going to the jury Monday or Tuesday. So we could have a verdict already as early as next week, Wednesday, or even Tuesday if it's a quick deliberation. So there was a number of things that happened today that was not actual testimony. Some other things that the judge had to take up, which was also quite interesting. So we're, of course, going to break everything down and explain everything, analyze everything, so you will be all set for tomorrow, the next day of testimony. And again, this case is wrapping up pretty quickly. So the first thing that happened was that there was reports that Eva Benefield, who is the daughter of Doug Benefield with his first marriage to Renee, she apparently had an interview with News Channel 8. This was reported to the judge. And he did not like that much for two reasons. Number one is that there is an order, or at least a rule, that there is no interviewing in the courthouse. That's not allowed. So if you're a news station and you want to come in and watch the trial and take some notes and report back, that's fine, but there's going to be no interviewing in the courthouse. And it seems from the reports that Eva was interviewed in the courthouse. So that's number one. Number two is that Eva is still under subpoena, and there is a sequester rule, and she is not allowed to talk about any of the testimony or talk to witnesses, which would include giving interviews. So the judge was not so excited by that. They called her in. The judge asked her some questions. The defense attorney asked her some questions, and that was it. And he admonished her not to talk to anybody again about this case until she is released from her subpoena, until she does not have the order of sequestering either. So that was one thing. And also the defense asked that she be stricken from being able to be called as a rebuttal witness. So even though she already testified, but she's also listed as a rebuttal witness. So in case the defense puts on a case and now the state wants to rebut some of the testimony that the defense puts on, Eva was listed as a rebuttal witness. So the defense asked that she should be stricken now because she disregarded the court's order that she should be stricken as a rebuttal witness. The state argues that really she didn't violate any order. She didn't talk about her testimony. She was just talking about the situation, not really what she testified to. So there was some argument there. But the judge deferred making a ruling specifically about whether he's going to strike her as a rebuttal witness. He's going to defer on that to see whether even the state wants to call her as a rebuttal witness. A lot of times you list rebuttal witnesses and you never end up calling them because you feel strong enough about the case that you already put on. So he's deferring the ruling, which is the right call, and we're going to see whether the state even wants to call Eva. So that's the first thing that happened before any sort of trial. The second thing that happened is that you will recall yesterday after the lunch break, the judge mentioned to the attorneys on the record that his office or his chambers got a call from a unidentified female reporter who told him that she has information about the case, or didn't tell him, but told his staff that she has some information about the case and she wants to tell the judge the information that she has in the case. And the judge said, no, we're not going to do it that way. If you want to have some sort of information sharing opportunity, you're going to have to do it in open court with the attorneys there so we can all hear what you have to say. So that's how it ended. She was suggested to do that, to come into open court. That's how the message got back to her, and she declined to do that. Well, the story picks up today because now the judge said, well, what happened now is that this unidentified female reporter is now represented by a law firm who is unnamed, a law firm, and the law firm let the judge know, sent a letter to the judge and to both of the attorneys in this case. And in that letter, in that email, or letter, it was told that this unidentified female reporter overheard, or at least was in a restaurant. And in that restaurant, she saw one of the sitting jurors in that restaurant. And there was a large television that was playing in the restaurant, and it had some coverage of this case playing on the television. And aside from that, near where the juror was sitting, there was two people talking about this case within earshot of that juror. Now, if you're a juror on this case, the judge already told you a number of times that you're not to listen any news reports about this, not to follow any social media about this. He always tells them that. That's what all the judges do now. And here you have a juror sitting in a restaurant where coverage of the case comes on in the television, and there's two people talking about this case in earshot of this juror. So the reporter felt that that was important for the attorneys and the judge to know, which is, yeah, it is important to know if one of the jurors is not listening to the instructions of the judge. So what the judge did is the judge called each individual juror out to ask them about what happened, if they were one of the people, if they were this juror. And again, the judge said, look, I'm just letting you know that I got this letter, I got this note. I'm not saying that it happened. I'm just reading to you what this report is. Do you have anything to share about it? And finally, one man did say that, yes, I was in the restaurant. I left right away. I didn't really hear anything. I didn't overhear the conversation. I was uncomfortable, so I just left, and nothing really changed about that situation. And of course, you're going to have some jurors that do come into some sort of contact. They walk into their house and something's on the news, or someone else is watching something. So then, yeah, they may have a few seconds of exposure to that, but we're not going to disqualify a juror for that. So there's no reason to disqualify anybody, and everyone was kept as a jury. So now, finally, they're able to go and move on to the testimony in this case. So we had Brian Quillis, who is a supervisor of the technical services unit. He testified, and he really just downloaded all of the information on Doug's phone and on Ashley's phone. And essentially what he basically went through is the text messages between them. And there's a number of text messages between them from September 20th through September 27th. And he went through a lot of those text messages. And essentially what the text messages showed was that this was very normal communication between a couple. And they were laughing at each other, and they were liking comments, and they were loving comments, and they were just interacting like normal people, saying goodnight, saying good morning, LOL. It just looked like a regular, normal couple. And they're trying to show that there's not like this major fighting going on. He's not being abusive in the text messages. He's not being threatening in these text messages. He seems like a regular, normal guy. And so does she, by the way. So it just looks like that's the type of relationship here. So they're trying to show that this is not an abusive, intimidating person, and that Ashley should feel that she's being somehow abused. And that essentially was the point of showing all those text messages. And okay, then on cross-examination, the defense attorney really just brought out that you don't really know the context of the messages. You don't know the reasons for those text messages. And as we're seeing what the theory of the defense is going to be, is that when someone is involved in an abusive relationship, they try to act like everything's normal with their partner, because they know if they don't, then that's how trouble gets started. And they don't want to be the victim of domestic abuse. So therefore, they do specifically make sure that all of their interactions are as nice and calm and happy as possible, so as not to trigger that person. So that's essentially what's going to be the defense's case here. He's going to be calling an expert, it seems like, in domestic violence to explain this all to the jury. So that's what we're going to be probably seeing in the defense's case. Now, there was an interesting argument also that was outside of the presence of the jury, and the defense wanted to introduce some of the Google searches that Ashley searched on her phone. And some of the Google searches included searches like living with an abusive partner, or how to parent with an abusive husband, things like that, which really shows what her mindset was. And the judge did not allow these Google searches in. Now, again, this was downloaded by this expert, Brian Quillis. He got all this information, so he got the Google searches also, not just the text messages. And therefore, he wanted to introduce these Google searches. And the judge did not allow it in because it's technically hearsay. And the defense argued back that, well, it's not really hearsay because I'm not offering it for the truth of the matter asserted. And I'm not trying to offer this to show that she actually, what the information that she actually searched was. I'm introducing it to show what her mindset was, that she's searching for how to live or how to co-parent with an abusive husband, and that shows where her mind is. So it's certainly a strong argument, at least in my mind, it's a strong argument to be made that this is a hearsay exception, because you're not offering it for the truth of the matter asserted. You're offering it to show that she is searching these terms because she's terrified, because she feels that she's living with an abusive husband or abusive partner. So I thought that was a very strong argument for it to come in, but the judge did not allow it in. So I guess we'll see if the defense in their case in chief tries to get this in some other way, but we will see. But I think it was an interesting ruling. I can't say that I completely agree with the ruling, and it certainly would have helped the defense's case. All right, then we had Dr. Russell Vega. Dr. Russell Vega was the medical examiner in this case. He performed the autopsy, a real expert. He's performed close to 4,000 autopsies, and some of the things that he observed in his autopsy was the following. Number one, Doug is 5'9", 169 pounds. And again, we're hearing this because the prosecution wants to show that he's not this scary 6'4", 250-pound man. He's, for a man, pretty petite, 5'9", 169 pounds. And again, we saw pictures of him, and he seems like he's very ripped and a very strong person, but still they're going to try to push that narrative. And then he talked about the injuries that he noticed on his body, which is there is a right shoulder injury. There is a right by the right side of his chest. That's where there is a gunshot wound. There is also a gunshot wound on his right leg. And also there was a bump on the back of his head, which is consistent with Doug falling backwards and banging his head, which is also, I think, a significant part of how he actually died, how he was shot, how he was positioned. He fell backwards and he hit his head. Now, also, he showed on his body exactly where the projectile went in his body and out of his body, which was the right side of his chest on an angle and moving up. So it was entered at the right side of his chest, not straight on, right side going up and through his body that way. Also, the bullet to his leg, the projectile that was shot into his leg, also was going up, and the entrance was at the back of his leg. So the entrance of the bullet was the back of his leg going and exiting out of the front of his leg. Now, how does that happen? Well, the prosecution obviously wants them to believe that he was running away. He wasn't coming after her. Well, as soon as she pulled out that gun, he said, fine, and he ran. And as he turned to run, that's when she shot him and went through by his side and also hit his leg while he was running, while he was lifting his leg up to run. That's how the bullet went through him. So that's going to be the prosecution's argument about how this actually happened, which would show that this is not self-defense. It's not self-defense if someone's running away from you. Then he also testified, which also came out later, that the weapon was at least 3 feet away from Doug. So it wasn't close contact, because then there would have been gunpowder and residue on his shirt or on his body. The gun was at least 3 feet away from Doug when he was shot. So that would also be more of an argument to suggest that this was really not self-defense. It's not someone who's in your face trying to smack you, trying to hurt you, and therefore you have to pull out a gun. Excuse me. So that is another significant part of this case. Also, then he testified that the cause of death was a wound to the chest, which a gunshot wound to the chest, and the manner of death was a homicide. On cross-examination, he pointed out that homicide doesn't necessarily mean that there is criminality behind the homicide, right? It could be justified. So that's, again, if it's self-defense, it still can be classified as a homicide, and there's still no criminality behind it. Also, an interesting point is that he couldn't determine the order of the shots, meaning where was Doug shot first? Was he shot first in the leg, or was he shot first in the chest? That wasn't clear, and he couldn't make that determination, which would also be helpful to kind of paint the picture, to try to figure out how this happened. Where was Doug shot first? Was he shot in the leg first? Was he shot in the chest first? That would kind of help us understand what happened here. So he couldn't opine about that. Also, he pointed out that it's not possible that the gun was shot when Doug's entire body was turned to the back. It had to have been a shot front, not from the back. And also, he said that the gunshot wound to the leg is consistent if Doug fell backwards and his legs lifted up. So if he fell backwards and his legs lifted up, and then the second shot was to his leg, that would be consistent with how the trajectory of the bullet went through his leg. So that is, again, the defense's theory here, that the first shot, or one of the shots that actually hit Doug, which seems to be the chest shot, that was the one that caused him to propel backwards. His feet got lifted up in the air, and the second shot went through his leg as his leg was in the air. All right, so that was the medical examiner's testimony. Then we had Daniel Hostorf. Daniel Hostorf is a crime lab analyst, and he examined the firearm. Everything was in good working order. He examined the cartridges. Everything was consistent with these bullets being shot by this gun and all that good stuff. And then also the fact that, I shouldn't say good stuff, but all that stuff, just confirming that this was the gun. It did work. The bullets were shot from this gun. Everything's matching up. Also, that there's no gunpowder on the shirt. All right, and that's it. Then the state rests its case. So the state's done with this case. They feel that they've now met their burden to prove second-degree murder of Ashley Benefield beyond a reasonable doubt. Well, now we always have, anytime the state rests, in all these cases, we have some sort of motion, and it's called different things in different jurisdictions. It could be called a directed verdict. It can be called, in this case, a judgment of acquittal. So here, after the state rests, the defense is almost always going to make a motion that the case should not even go to the jury. The case shouldn't go to the jury. The prosecution has so clearly not proven their case, certainly beyond a reasonable doubt, that we can't even let the case go to the jury. And therefore, the defense attorney argued the following. His main argument was the fact that second-degree murder, one of the elements that's required, is a depraved mind or a depraved heart. So here, how do you show that Ashley Benefield had a depraved heart or a depraved mind when she shot Doug Benefield? How do you show that? We know that she shot him. There's no question about that. The prosecution proved that. But how do they prove, where's the evidence that she had a depraved mind or a depraved heart when she shot Doug Benefield? And that would include ill will, meaning if you can show evidence of ill will or hatred. Was there any evidence? In fact, all those text messages showed that everything was great. Everything was hanky-dory. Everything was great. Wonderful. So where's the evidence that there was any sort of ill will that the prosecution put on? Also, maybe there you can say that there's an element which would include indifference to human life, which is part of the depraved heart. And here you don't see indifference. In fact, she ran to a neighbor. She didn't just leave him to die. She ran to a neighbor right away and told the neighbor what happened. And the neighbor called 911. She didn't tell him not to call 911. So there's no indifference to human life. So that was his argument. And then he also argued that the state didn't even prove or disprove that this was not a case of self-defense. So that's the basis of his motion for a judgment of acquittal. Even after the state has rested, there's just simply no evidence that she acted with a depraved heart. Now, the state responds. And the state responds that, first of all, it's not just ill will or hatred. Also included is spite or evil intent. That's also included in the depraved heart. And let's remember that it was already testified to that she tried to get one of the witnesses to arrange for Doug Benefield to get arrested in the middle of court. Right? That was came out yesterday. That she was asking to get him arrested in the middle of court. And she told him on the phone, I will do whatever I need to do to keep my baby. And that very clearly shows, if we just accept that in a vacuum, I'll do whatever it takes to keep my baby. Well, that would include evil intent, spite, That's ill will. That could be hatred. That you will do whatever it takes to keep your baby, including murdering somebody for that. Also, let's not forget all this ill will by all these false complaints that she filed. And no prosecutions were ever pursued from all of these complaints that she filed for domestic abuse or domestic abuse against her baby or even sexual abuse against their baby. None of that ever was substantiated. It was all false, which also shows that this is a person who has certainly ill will towards Doug. Also, let's remember, she shot the gun 4 times. She shot it 4 times. That also shows a depraved heart. That can be evidence of depraved heart. And also the evidence that he was actually running away. The evidence that the bullet went in at the side, not straight on, and also in his leg, which would seem to suggest that he was running away. So that's depraved heart. What are you shooting someone who's running away? So the defense actually argued to the judge that no reasonable jury can find, looking at all the evidence, that no reasonable jury would be able to find beyond a reasonable doubt that Ashley Benefield committed second-degree murder. But the judge corrected him, and the judge said that's actually not the standard. You got to get your standards right when you're arguing, right? The standard here for the judgment of acquittal is if you view all of the facts in the light most favorable to the prosecution and all favorable inferences to the prosecution. So it's not like you're looking at all the evidence and saying, all this evidence in front of me, what would a reasonable jury decide? That's not the standard. And he said, that's the standard if you want to renew this motion after you finish your case. But at this point, for a judgment of acquittal, the standard is that we look at all of the evidence in the light most favorable to the prosecution. Meaning if there is an inference to be made that would help the prosecution, that is what you look at, and you ignore the other evidence that contradicts that. So if there's any sort of evidence which would help the prosecution in any light, that's how you have to look at all the evidence. So first of all, he corrected the standard, and then he said, well, if you use that standard and we just look at all of the evidence that came in that would help the prosecution win their case and ignore any sort of the other types of evidence, then certainly the jury could find beyond a reasonable doubt that that Ashley Benefield committed second-degree murder. Then after that, there was something called a Richardson hearing. Okay, what's a Richardson hearing? Because they keep talking about a Richardson hearing, and it's really a Richardson hearing is really also a very similar hearing that you have in almost all different types of jurisdictions, and that has to do with discovery. Okay, there's always arguments about this is trial by ambush, this is trial by surprise, you're trying to sandbag me last minute. These are arguments that we always hear. You didn't turn over that discovery, now you're trying to introduce it. So we have here, what we had is that the defense wants to introduce some emails that included one of the judicial assistants or one of the judicial clerks with one of the judge that was handling the family matter. And remember, there's an attorney, Stephanie Murphy, who testified. She was the attorney for Doug Benefield. And there were some emails that talked about what the September 30th hearing was going to be about. And this is a very important part of the case because the prosecution's theory here is that because Dr. Broder's report is going to come out on September 30th, and she knew, Ashley Benefield knew that she did not want that report released. She didn't want that report, Doug Benefield, to see that report. So that's why she murdered him. That's the theory here. But the defense argued very strongly that there's some emails which show clearly that was not going to happen on September 30th. September 30th was only going to be a hearing about the petition that Ashley Benefield filed for a restraining order and nothing else. However, Stephanie Murphy testified. Remember, her testimony was that you're right. Initially, that was what was going to happen. But since mediation happened before then, so things changed by the mediation. And then, therefore, the focus of the hearing on September 30th also completely changed. But nevertheless, the defense wants these emails introduced to show that these emails show that no, September 30th was going to be just a hearing on the injunction, on the restraining order. And that's it. And if he can show that, then a big part of the theory of the prosecution's case goes out the window. So he wants to introduce these emails. And the prosecution argued that this is a Richardson violation, which means that you are supposed to turn over all discovery. And since you did not turn over all discovery, so you cannot introduce it now. So this is always an issue that you have in all trials. Was the discovery turned over early enough that we can know what's going on, and the other side has notice and they can prepare for it, prepare cross-examination, maybe hire their own expert witnesses to contradict it, whatever they need to do, you have to be able to turn that information over. And this was the argument that this was not turned over early enough. And here, it's not so simple because really the prosecution did have access to these emails. It's just that the defense didn't specifically say we're going to use these emails. So really they had them. So there's some sort of Richardson hearing that went on. And the judge basically said that we're going to allow these emails in. And the witness is going to be one of the judicial attorneys or judicial assistants. They're going to come in and testify to authenticate these emails. And the judge is allowing the state to take her deposition before her testimony in open court. So that's what happened today in the case. The state rested. This case is wrapping up very quickly, and we will see how the defense's case plays out when they put on their evidence and their testimony. So that's it for now. Please, if you haven't yet, like, subscribe, and we will see you next time.